Good evening, this is John Milburn. Please excuse my voice tonight. It may break for a little while, after a little while rather. Tonight is week 7. This is Laws 11046, Law in the Environment, and tonight we're dealing with the topic of environmental impact assessment. And there is one problem set for the work this week. Before I talk about environmental impact assessment, I just want to take a few moments to speak about the exam. Now, the exam format, firstly, is one where you are required to answer the questions in a booklet. I'm sure that you're all familiar with that concept. And the exam requires you to answer parts A and B. Now, part A is compulsory, and it's worth 20 marks, and it's a single question. Part B is worth 30 marks, and students are required to answer 3 of 5 questions. Now, not unsurprisingly, those questions are all of equal value, 10 marks each. So 20 marks in Part A and 30 marks in Part B. Sometimes, well, I'll correct that, every year, at least one student answers more than is prescribed, will answer more than 3 questions. And if that happens in this intake, I'll only answer the first 3 that are there. So please make sure that you only answer 3 questions. The exam, as you know, is open book. Now, what that means, of course, is that you can take in your textbook, you can take in law dictionaries, study modules, you can take in your own notes, you can take in pretty much anything other than a device to join the internet. You can't take a standard dictionary and you can't take a calculator. So if you think you know what the answer to a question will be, then why not write the answer now and take it in with you so that you've got maximum opportunity to express yourself in the way that you would like and take away some pressure while you're in the exam context. Now, of course, being an open book exam is terrific in some ways in that it does take away some of the pressure to rote learn. However, the trade-off is this, that given that it is an open book exam, given that I do provide you with hints from time to time as to what the content of the exam will be, and that now I've told you that you can actually write your answer, the trade-off is that I expect a better standard of work than would be the case if it was a closed book examination. All right, now part A. This is the part that will really get you thinking. Part A is as if you were working like a lawyer. So it's a law course that we're doing, and this particular question, I want you to think about it as if you're the lawyer involved. And you might be acting for a party that is involved in some sort of environmental law dispute, obviously enough. Now, it won't take you too long to work out the parties that you could be called upon to represent, hypothetically, in the Part A question. Well, it might be a developer/owner of property. A developer wanting to do something with a property and having difficulties. So there's a fair chance it'll be that. Or it could be an objector, or a submitter, if you like, to a particular development proposal, or it could be a council. So they're the really options. I guess that's pretty obvious. Now, you might be acting for the hypothetical developer or the submitter or a council, and the scenario may relate to a proposed application, and you may have to provide advice with respect to a merits appeal. That's one option. Second option is that it could be an alleged failure to comply with conditions of a development permit, and you are to provide advice with respect to enforcement options, or that's if you're a council, or anticipate the enforcement options that may be brought against you if you're the developer. Now, that deals with the merits review and the administrative side of things. The criminal law side of things that we haven't got to yet in the course may come into play as well. And it may be that the hypothetical examination question relates to an alleged failure to comply with environmental laws generally. And in your role as pretend lawyer, you may be called upon to provide advice in relation to the proposed prosecution of the failure to comply with environmental law, or a proposed defence to a prosecution. But I'll ask you to answer the question from a particular perspective. So I hope that that's given you some guidance as to what Part A might be all about. And if you have any questions, please feel free to unmute and ask. Particularly, that would be good while my voice is failing me, or to ask a question through the chat facility. All right, so when it comes to preparing for this examination, I guess you're going to have to work out what to do. Now, I'm going to suggest, as I often do, that you work backwards. So if you were looking at a decided case in any one of those scenarios, you might ask yourself the question, how did it get to this point? And what I'm asking you to do is give the advice to a party which precedes the case in one way or the other. So in a sense, think about the end result in the cases that you've read or you've referred to. Think about how they got there and then work back from that. And that logically then should give you the mindset to describe what type of advice should be given to the party in question. Really importantly, do read the material facts. Now, when I talk about the material facts, and there's been some discussion on UCREW about this, what I really mean are those facts that make a difference. So it doesn't really matter whether the property in question or the environmental or the allegation of environmental crime occurs on the Gold Coast or in Cairns. That shouldn't really matter. It may do, but you have to ask yourself, is that a material fact? It may be that a material fact relates to something that will be argued about in the court case, and that's really what it comes down to. So it may be that the type of vegetation is not particularly relevant, but the extent to which the vegetation was considered as part of the hypothetical situation might be a material fact. So think about what's important and what might be argued about if the matter goes to trial. Go back to basics. You'll recall, I think I discussed the MIRAC method. Think about the material facts. Think about the legal issues. Think about the rules. Think about how to apply those rules and come to a conclusion. So that's a good template for problem solving. So Part A is all about problem solving. Part B is much easier, essay-style questions. They'll come from any part of the course. And given that there's a choice of 3 from 5, I won't give any further hints as to the likely source of those questions, but I will give you some general guidance in relation to answering those essay-style questions. Have a look at my sample document. That'll give you some idea about referencing. Have a look at your textbook. Have a look at the way that's set out, and that'll give you a guidance to legal writing generally. So are there any questions at this stage? Otherwise, I'll continue. Keep going? All right. Okay, in your reading for this week, you need to consider a number of different topics in relation to environmental impact assessment. Now, I already do have a lot of material uploaded through YouTube onto the Moodle site in relation to this area. I'd commend you to consider the Moodle videos that I conducted with Phil Jeston, environmental scientist, and he talks about environmental impact assessment. And also Sean Ryan from the Environmental Defenders Office, and I had a good discussion with class members in relation to some of those things as well. And Juliet, I'm just going to mute your microphone if I could.
I wasn't hungry enough for Zimmer every day.
Okay, well, do you want to go to the...
Just may have to go to gallery view here to do that. I'm having difficulty in muting your microphone, Juliet. Juliet, normally I can. Now, if we think about environmental impact assessment, you need to think about the need for the assessment. It's not every environmental issue that requires a full-blown environmental impact assessment to be undertaken. So think about what are the triggers that determine the need for the EIA to take place. And think about the role that the environmental impact assessment does have in decision making. Thanks, Juliet. Now, what you would have already picked up upon is that there is the dichotomy between the federal and the state. And we'll talk more about this later in the course, and I think your second assessment requires you to consider this in more detail. But in the federal sphere, there is the requirement to undertake environmental assessment of matters that are of national environmental significance. So think about that term, national environmental significance, and cross-reference that to the need for a federal environmental assessment to be undertaken. And when you're doing that, remember, of course, that there are the federal-state cooperative arrangements which avoid the requirement for a developer to undertake environmental impact assessment both at a state and a federal level. So the federal-state cooperative arrangements, the bilateral agreements as we call them, are important in that regard. When you're reading the material in relation to environmental impact assessment, think about some terms and try to understand these basic terms. Now, one of them is a controlled action. Think about that. Think about the referral process, and ultimately make a decision as to what is the appropriate method of assessment. In other words, an environmental assessment is not necessarily going to be the same thing for all developments. Think about the terms of reference that apply and how those terms of reference come about. And in doing that, you may have to consider the state-based environmental impact assessment regime. And in that regard, I'd ask you to look at the State Development and Public Works Organisation Act of 1971. It's a Queensland Act. And if you can follow that and read some commentary about it, then it will give you a good idea as to the processes in relation to EIA that I've described in brief form. And then think about some of the common criticisms of environmental impact assessment. So if you're struggling with it, have a look at my notes that I prepared, which are in Moodle, and hopefully there's some flowcharts there, there's some information that will make it a bit easier for you. But websites are very good, both at Commonwealth and state level. There's a lot of very good explanatory memorandum and advice there. All right, so I mentioned that you need to understand and think about the purpose of an environmental impact assessment. It's not needed for every decision that is environmental based, only some. But one of the main important things is this. You need to consider how decision makers and the public are informed about different outcomes of a proposal. Now, I invite you to think about what type of outcomes we're talking here, because it's a little misleading, but I'll give you a hint. When we're talking about the type of the outcomes of a proposal that you might expect to see canvassed in an environmental impact assessment, I'd ask you to think about the definition of ecological sustainable development, because ecological sustainable development covers not just the ecological issues, but it also deals with social and economic issues as well. So from that, it follows that an environmental impact assessment provides information about outcomes of a proposal relating not only to the environment, but also the social and also the economic. Thinking about an environmental impact assessment purely in terms of the environment is incomplete thinking, is the point that I want you to take from that. And as I said, my authority for that proposition is the basic definition of ecological sustainable development. From memory, does anyone remember the section number of Ecological Sustainable Development and Sustainable Planning Act? I'm just kidding. You can just buzz in with that. It's always good to know a section number offhand. I'll leave you to look that one up so you can answer that one next time. In an environmental impact assessment, you'd also expect that the assessment will deal with management of impacts and how it's likely to affect the environment significantly. This is where, I'm sorry my voice is going on me, so I'll have to wrap it up fairly quickly, but this is where the new legislation going through Parliament now is extremely interesting, and the discussions about the long-term impacts and probably a criticism that those impacts were not either adequately explained at the EIA stage before the decisions were made, or if they were not appropriately catered for at a parliamentary or administrative level. Now, I'm not suggesting that is the case. I'm just proposing it as a potential criticism. And I guess logically, we wouldn't be having discussions about clean-up of mines if those issues had been adequately addressed at the EIA stage. All right, so what else do you expect would be an environmental impact assessment? Well, I guess you'd probably expect to see something about the conditions that might be imposed, and some discussion about that. And then, of course, there is the fourth one, is monitoring the predicted and actual impacts, and having an audit regime in place to ensure that there is adequate adherence to approvals and conditions, and maybe identify additional or alternate proposals. So, in summary, 4 things that you'd expect to see in an environmental impact assessment. Something that will inform people about the likely outcomes, environmental, social and economic. State how to manage those impacts. Thirdly, identify what conditions might be imposed. And fourthly, monitor both the predicted and the actual impacts and have some sort of auditing regime in place. Now, at the start, I mentioned that you need to understand some basic terms. One of those is controlled actions. And you'll see that term referenced in the context of environmental, federal environmental law. So if a matter is of, this is now we're talking the state, the EPBCA, the federal EPBCA. If a matter is of national environmental significance, then it'll be a controlled action, and in those circumstances, the proponent must consider if the proposed action needs to be referred. Okay, so just try and understand what that means, this concept of a controlled action and the proponent referring it. Phil Jeston gives some really good information about this in the YouTube clip. So the first question is the threshold question, and I'm talking now federal. Question is whether the proposed action is likely to have a significant impact on a matter of national environmental significance. That's the first question. And the second question, which is in a way allied with it, and it's not sequential, it's just one or other, whether the proposed action is likely to have a significant impact on the environment in general. Now, that's for actions by Commonwealth agencies on Commonwealth land or on the environment on Commonwealth land generally. Where the actions are or likely to have significant impact, then the proponent must seek and obtain an approval from the Australian Government Minister for the environment. So federal ministerial approval is required in those circumstances. And you'll see that often referred to in the material. So keep an eye out for that as well. All right. My apologies. I'll get you to read something about bilateral agreements and projects under the State Development and Public Works Organisation Act. I'm going to put up on the screen a flowchart, and this is I'll share the screen now. So you should see something on my screen now. And and I'll just see if I can make it a bit bigger so it's a bit easier to read. All right, so a proponent. Now, what do we mean by a proponent? Well, really a developer or a proposer. So a proponent of a coordinated project must prepare an environmental impact statement or an impact assessment report. And the environmental impact statement is prepared in accordance with the terms of reference for the EIS. And I've sourced from the Queensland Government Department of State Development a flowchart showing the steps in the assessment process. Now, I may have actually included that in my Moodle notes, but if not, I'd urge you to have a look for that on the website. And if you can understand those terms and that process, then that's probably much easier to read from a flowchart than it is to try and work your way through the sections of an act. So I'd ask you to consider that. All right. Because my voice is going, it'll be a short session, and we're pretty close anyway. So there are some criticisms which I've outlined in the notes in relation to the process. Phil Jeston makes reference to some of those criticisms as well. These things are enormously expensive potentially. Environmental impact assessment for a large controlled action, matter of environmental significance nationally, can cost millions of dollars. Consider what Phil Jeston says in that regard. And bear in mind that there is so much to lose that, and I have to be careful how I say this, but perhaps I could say in general terms, one criticism might be of a perception. Now, it might be real or it may simply be perceived, that a report writer will tailor the report to suit the party that is providing the funding for that report. Now, that should never happen in theory, but it may be something that people consider as a potential criticism. I would normally at this stage go through last week's problem or problems, but what I might do is simply refer you to Moodle, and in that regard, as I recall, I've put up my notes in relation to last week's problem. Is that the case? Did I actually do that? I think I did. If not, I shall do that. All right, so next week we have our assessment due, our first assessment. Are there any questions about that, or questions generally? And I might just go to gallery view if that's okay. All right, so anyone got any questions about what we've covered tonight or the assessment regime? Any material? All good? Okay.
I think Kelly had a question about referencing.
Kelly, did you have a question? Thanks, Madonna. No? All right. Well, of course, if there's any questions. Oh, okay. Yes. The question is, how to refer to the judge? That's a really good question. When you are, firstly, in the district court, we refer to a judge generally as judge. In the Supreme Court or Federal Court, it's justice. You may have seen that. So to give some examples, in Queensland, in the Supreme Court, we would refer to His Honour Justice Applegarth of the Supreme Court as opposed to His Honour Judge Devereux of the District Court. But in referring to a judge or justice, and a justice is a judge, it's just a different term that we use for Supreme Court. Quite often you may refer to the judge as his or her honour. Another way is to say Applegarth J or Devereux DCJ. And that's just going to have to do. Won't be a sec, sorry. My apologies, Kelly. I almost got that answer out, but I'm gone. So that might have to do us for tonight. But in the assignment, you can put the judge's name in full. You can say, yeah, hot lemon and honey drink. Yes, that's a good idea. You can say, for example, Judge Rackerman, DCJ, or Rackerman, DCJ, or Judge Rackerman, or His Honour Judge Rackerman. So there's a number of different ways, but it should always be polite and formal. A good way of doing it is to have a look at the way courts refer to other judges in a judgment or in the textbook, and probably in my notes as well. They should all be pretty consistent. So there's no one right answer, but there are a number of different answers to that question. I hope that helps, Kelly. All right. Well, thank you very much for joining us tonight, and we will see you next week. Please make sure you submit your assignment on time. Don't rush necessarily to submit it straight away. Some of you may have already submitted your assignment, but bear in mind that in the last week, there's often some questions in UCREW asked and answered that might help everyone. So keep that in mind as well. All right, well, I'll stop the recording now, and thank you very much for joining us.